I've had a chance to look at the John Magnier decision in the Barne Estate case, Mr. Justice Max Barrett's decision. 74 pages. It's an excellent decision insofar as it breaks down every aspect of the formation of a contract in Irish law, part performance, the need sometimes for a memorandum of the deal, a note or memorandum in writing, and so on. But all through, there is a fear on Magnier's side that Maurice Regan will come up on the inside. And in fact, it's apparent from reading of the decision by Mr. Justice Max Barrett that Regan didn't need to come up on the inside because Maurice Regan made all from the front. Let's have a look at the decision of Mr. Justice Max Barrett. And if you're a student of law, if you're a student of estate agency or being an auctioneer or a estate agent, or if you have an interest in property law and so on, this decision, the 74-page decision issued yesterday by Mr. Justice Max Barrett, is well worth a look. Okay, let's have a look. Okay, let's take a look at this decision, 74-page decision of Mr. Justice Max Barrett in the John Magnier and Barne Estate case. And I want to take you through some paragraphs here first. Firstly, you'll see there paragraph 46. In light of the preceding analysis, it's worth briefly revisiting and expanding upon several central conclusions that run through this judgment and which are amplified on later below. We don't need to have a look at later below, but what we do need to do is look at this précis or conclusion or summary of Mr. Justice Max Barrett's decision. Paragraph 47. First, the plaintiffs have not discharged the burden of proving on the balance of probabilities that a binding land sale agreement arose from the kitchen table meeting at Coolmore on the 22nd of August 2023. With that central plinth removed, much of their case falls away, though other strands fail independently. It's worth noting here that Max Barrett, the judge, decides that on the balance of probabilities that a binding land sale agreement did not arise. In other words, Magnier failed to prove that there was actually an agreement from the Coolmore meeting in August 2023. If that's the case, then there's no need for a memorandum or note in writing to make the contract enforceable because there was no contract. And that's the central finding of Max Barrett in this case. He actually finds that the question of having a note or memorandum in writing to prove the case, to prove an enforceable contract, the need for that, pursuant to the legislation and the Land and Conveyancing Law Reform Act, there's no need for that. We don't need to go there because as far as the judge is concerned, there wasn't actually any contract arising from the meeting in Coolmore. Second, he says the evidence does not show consensus on all essential terms. The plaintiffs were aware that the lands were held in trust and no attempt was made on the evening of the 22nd of August to commit any arrangement to writing. Third, none of those in attendance from the defendant's side on the 22nd of August 23, that's from the Barne Estate side, had authority to commit the vendor. And the vendor, remember, is the trust that owns the Barne Estate. Only Barne Estate Limited, acting through its directors and authorised signatories, could do so. The proposal communicated to the company the next day was accepted subject to contract, which by its nature was not a final agreement. The events that followed confirmed that any potential sale was to proceed in the conventional way by signing and exchanging the Law Society's standard contract form. Fourth, the idea that a concluded contract was already in place is inconsistent with the parties' later decision to execute an exclusivity agreement expressly negating any prior contractual commitment. The stated rationale to stop anyone getting up on Coolmore's inside before contract cannot be reconciled with the existence of a completed bargain. The plaintiffs have never explained how such a risk could arise if the sale was already agreed. So this is important. Why would Magnier and Coolmore, that side, why would they need an exclusivity agreement if they had a deal done? Fifth, Because no oral agreement was ever formed, Section 51 of the Land and Conveyancing Law Reform Act of 2009 is not merely unmet, it is not engaged. This Section 51 of the Land and Conveyancing Law Reform Act of 2009 deals with the need, in order to have an enforceable contract, to have a memorandum or note in writing setting out the 4 Ps: the parties, the particulars, the price and the property. But the judge in this case says, because no oral agreement was ever formed, the question of meeting or finding or proving a memorandum simply doesn't arise. It's not needed. Sixth, the criteria for part performance as set out in Mackey v. Wild are not satisfied on the evidence before me. Seventh, although the oral evidence contained conflicts, most do not require resolution. The documentary record and the parties' conduct are enough to show that any alleged land sale arrangement, if it came about at all, and I hold that it did not, would have been provisional, incomplete and contingent upon formal contract execution. 8. Bearing in mind Stapleton versus Doran, in particular, the judge's observations at paragraph 4 and 5 of his judgment, I find that there was no mutual intention to form either of the alleged land sale or option contracts. There was no agreement on all material terms, and when it comes to the option agreement, there's no credible foundation for it ever having come into being. So any argument that there was any proposition that there was an option agreement simply doesn't arise. Ninth, by way of addendum in the just made point, the assertion that an option agreement was struck is unsupported by credible evidence. It appears in no contemporaneous record, was unknown to the party's solicitors, and even if one accepts for the sake of argument that there is credible evidential support for its existence, and there is not, it lacked agreement on essential elements as to, for example, consideration and duration. 10th, the notion that such an option existed alongside a concluded land sale is equally unconvincing. The continued discussion of an option pathway is characteristic of ongoing negotiation, not of contractual closure. 11th, the plaintiff's attempt, that's Magnier's attempt, to downplay the subject to contract formula cannot be accepted. The phrase was in use contemporaneously by both sides' solicitors and is entirely consistent with the absence of a concluded agreement. 12th, the plaintiff's credibility is challenged by the evidence in relation to the 22nd of August meeting. The issue is not the ordinary fading of memory, but the alteration of sworn testimony on the key question of trustee approval. Whether deliberate or inadvertent, the shift gives the appearance of recollection altered in light of the evolving case presenting. This is absolutely key. This has to do with Magnier's claim in his statement of claim and in his sworn affidavit that the Magnier or that the Barne side had gone out and at the meeting in August at Coolmore and had obtained the consent of the trustees, and yet the phone records, when they were produced, showed that no phone call was made to the trustees. And therefore what the judge is referring to here is the alteration of sworn testimony. In other words, Magnier had to go and amend his claim and had to accept that his affidavit wasn't entirely accurate. And as I say, the judge is asking here whether deliberate or inadvertent, and he said the issue is not the ordinary fading of memory, but this key evidence, phone evidence or lack of phone evidence about a call to the trustees, that scuppered that aspect of the claim that Magnier had, and that was, and he put it on affidavit and he put it in his claim, that aspect was that the trustees had approved it that evening at the Coolmore meeting because the phone call wasn't even made. 13th, the plaintiff's criticisms of Mr. Regan are not material to whether either the alleged land sale agreement or alleged option agreement was formed on the 22nd of August. 14th, the exclusivity agreement undermines the contract claim in itself. It imposed no duty to conclude a sale, and its expiry without a contract of sale being concluded involved no breach of any nature. 60, in essence, the plaintiffs seek to hold the defendants to terms that, on the evidence, were never agreed under contracts that were never made. the theory of binding oral agreement on the 22nd of August 2023 as to the alleged land sale agreement and the alleged option agreement is not supported on the evidence. The trustee approval condition, the exclusivity and tillage arrangements, the consistent subject to contract framework and the unresolved matters all point in the same direction: no enforceable agreement, be it the alleged land sale agreement or the alleged option agreement, was concluded on the night of the 22nd of August 2023 at Coolmore House. For completeness, I emphasise that the conclusions reached above and herein rest on two interlocking foundations. First, the contemporaneous documents and objective conduct of the parties, which are admissible and probative of contractual intention, overwhelmingly support the defendant's case that no binding agreement was made on the 22nd of August 2023. Second, and separately, the plaintiff's conduct or account of the meeting, as presented in multiple iterations across pleadings and affidavits, is internally inconsistent in ways that cannot be attributed to minor lapses of recollections. Those findings taken together satisfy me in the balance of probabilities that there was no consensus ad idem on essential terms of either alleged agreements and no intention to be bound by either such alleged agreement. So that is why Magnier's case has failed. There's a couple of other points I want to make in relation to this. At paragraph 68, the judge says several features here strongly suggest the absence of an intention to be bound at the kitchen table meeting. The asset was high value land, held in trust through a corporate entity. The vendor had appointed both professional agents and solicitors. The discussion was informal. Key terms were left open. The matter was explicitly referred to solicitors for progression. Early correspondence carried subject to contract notations, and an exclusivity agreement was subsequently executed, which itself described the stage as pre-contract. In other words, the exclusivity agreement in its terms described the stage at that point as pre-contract. If that's the case, and it is, then by definition there was no contract. At paragraph 89, there is an interesting statement there from the judge. He says the only actual agreements that emerged in this saga were the exclusivity agreement and a tillage licence. Both documents assume that there is no existing binding sale contract, and none of the plaintiffs or their employees appear to object to that omission at the time. So the judge is pointing to the fact that there's only actually two agreements, actual agreements, that emerged in this saga, and both of them assume that there's no existing binding sale contract. For students then of the law, for, as I say, students of law or auctioneering students, estate agent students or others with an interest in law, there's a couple of things there that I want to bring to your attention from this decision. One, the note or memorandum in writing. Section 51, subsection 1 of the Land and Conveyancing Law Reform Act 2009 provides in substance that no action shall be brought to enforce a contract for the sale or other disposition of land unless the agreement or a memorandum of it is in writing and signed by the person against whom the action is brought or their authorised agent. And subsection 2 preserves equitable doctrines such as part performance. He goes on to say that the requirement of section 51 subsection 1 presupposes the existence of a concluded oral contract. It does not itself create contractual obligations, but operates as a rule of proof. Where, as I have found here, no oral contract was ever concluded, the section is not merely unsatisfied but not engaged. In the absence of an oral agreement, there's nothing to be recorded or made the subject of a memorandum for the purpose of section 51. Judge is making the point here that the question of a note or memorandum in writing is simply not required because no oral agreement was ever arrived at. In other words, there's an absence of an oral agreement, so you needn't be worrying about the proof of an enforceable contract because no such contract ever existed. He deals with a question of alleged part performance. He says the doctrine of part performance cannot bring a contract into existence where none was made. He says, given my earlier finding that there was no alleged oral land sale agreement or alleged option agreement concluded on the 22nd of August 2023, part performance of same does not arise. And he says, for completeness, I should add that actions such as ploughing fields, paying a booking deposit or offering employment are equally consistent with parties proceeding in anticipation of, but prior to, a binding land sale contract. To treat such preparatory measures as part performance would be to collapse the distinction between negotiation and obligation. That's interesting, because any allegation of part performance, the judge is making a point here that the various actions taken in support of the contention that was part performance could actually also be equally taken in anticipation of, but prior to, a binding land sale contract. And finally then, in conclusion, he says, in relation to the alleged contract for the sale of lands, I found that as of the 22nd of August 23, there was no mutual intention to create legal relations, material terms remained unsettled, and no person present had authority to bind the defendants to a concluded sale. Any putative agreement was at all times contingent upon trustee approval. The failure of the plaintiff's case on any of these grounds would be fatal. I have found against them on all of these grounds. For completeness, and in case I'm wrong in any of my primary findings, I would in any event dismiss the plaintiff's claim concerning the alleged land sale agreement on the remaining findings. As to alleged option agreement, the plaintiffs have not shown that even an outline arrangement was reached on the 22nd of August 2023. The contemporaneous records indicate the absence of any agreement in principle on essential terms, including price, and I'm satisfied that there was no meeting of minds as to any binding option agreement. In reaching my conclusions, I've given particular weight to the reliability of contemporaneous documentary evidence over later inconsistent accounts advanced by the plaintiffs. That's very, very important. The judge here is pointing to the fact that where you have contemporaneous documentary evidence, and that, remember, is contemporaneous, it's made at the time, and later on then you have inconsistent accounts advanced by the plaintiffs. Which evidence are you going to give more weight to? Obviously the contemporaneous documentary evidence, because that was made without any contemplation or anticipation of litigation. The later statements obviously were made in the heat of battle in the litigation, or when litigation had commenced. As mentioned, the plaintiff's narrative has shifted materially since their initial letter of claim and the swearing of entry affidavits by their principal witnesses. That evolution, particularly as regards what was said and by whom on the 22nd of August 23, undermines the reliability of the plaintiff's account and reinforces the weight I have placed on the contemporaneous documentary record. So you can see there the judge is accepting the records, the contemporaneous records of the time, and is taking the view that Mr. Magnier's evidence later was, the reliability of it was undermined. For completeness, the declaratory relief sought under Section 52 of the Act requires an enforceable contract for the disposition of an interest in land. As I have found no concluded land sale contract, no question of a statutory trust or vesting arises under Section 52, so that relief is refused. For all of the reasons stated in this judgment, and on the basis of the facts as I have found them, the plaintiff's case must and does fail in its entirety, and all reliefs sought are respectfully refused. The judge then goes on to do something else I've never seen in a case before, in a decision before. I don't see that many of them, quite frankly. I'm busy enough doing other stuff. I don't read that many High Court decisions, but I've never seen this before. The judge actually goes on then in an appendix, and in the appendix he actually deals with, and he says this appendix is part of my judgment. He says what follows proceeds strictly in the alternative and on the footing contrary to my primary finding that an oral contract was made at the meeting of the 22nd of August 23. So he now goes on to deal with an alternative version of events, an alternative decision. And the alternative decision is that there was an oral contract made at the meeting on the 22nd of August 23, even though he doesn't accept that. But he's actually dealing with the possibility that even if you accept that there was an oral agreement made, he then looks at for the avoidance of doubt, even if I had found that an oral agreement was concluded on the evening of the 22nd, 2023, which did not occur, and that Section 51 of the Land and Conveyancing Law Reform Act 2009 was engaged, which did not occur, and this is the one to do with memorandum or note in writing. No note or memorandum in writing sufficient to satisfy Section 1 has been identified in these proceedings. And the judge then goes through, firstly, the legal principles surrounding the note or memorandum in writing, and he deals with how it can come about, and it doesn't have to be one document, it can be a number of documents, and it can come into existence inadvertently. It may consist of internal communications, it may be contained in a single document or several documents, etc., etc. So he deals with the question of a note or memorandum and how it can happen and what you need. But he then goes on even further to look at all of the documents. He says, bringing those principles to bear, I make the following observations in respect of the various documents that the plaintiffs have sought to rely on. So the plaintiffs had various documents, and I think there could be 50 documents. He goes through every one of them and states that this is not enough to constitute a note or memorandum in writing to satisfy the Land and Conveyancing Law Reform Act of 2009. And he says if the parties are uncertain as to which document is being referenced in any one instance, they should apprise the court and further detail can be provided. And he goes through then document 1, 2, 3, 4, 5, 6, 7. He goes right through documents 23, 25, document 29, document 33, 36, 37, 40, 43, 48, 52, 53, 56, 57, 58. 58 documents. He goes through 58 documents, and he says, taken at their height and individually or collectively, the documents identified by the plaintiffs do not satisfy Section 51 of the Act of 2009. I mentioned in my video yesterday that Magnier might appeal this to the Court of Appeal, but quite frankly, having read the decision last night at home and having gone through it there now with you, I couldn't see any way that an appeal at the Court of Appeal could succeed based on this decision. The Court of Appeal might take a completely different view. If to do, more luck to them, and if John Magnier wants to throw more money at this case, he's more than welcome to. He has plenty of it, apparently. The other thing is the judge has made no decision about costs, I understand. Let me just double check that. But I mean, I can see only one winner here in relation to costs, and that is the Barne Estate must be awarded their costs. That is my view. It's up to the judge. I'm no judge. But I think, yeah, I will hear the parties as to costs. He says at Section 220. But I mean, I can't see any way that Magnier is not footing the bill for costs all over the place. He's footing the bill for Barne Estate, and he's footing the bill for himself, because the basic rule is costs follow the event, winner takes all, and in this, and the judge does have discretion to depart from the usual rule, but there's absolutely no reason here, or no inkling or no suggestion as to why the judge would depart from the usual rule, and that's why I think costs will be definitely awarded against John Magnier. That's just my idea, or just my opinion rather. What do you think? If you like the video, hit the thumbs up button down below. Thanks a lot.